give you a sense of how, even with the threat that humans have posed to the planet, the best we have done in regulating environmental issues is protecting humans from the threats that we've posed to the planet, and not taking a broader view, even with climate change as the major threat we now face. So what we often forget, and what the book is really proposing, is that the idea of being on the planet together, humans, wildlife, natural resources, the traditional model has been humans are in charge, and basically everything else on the planet are resources for our use and consumption and enjoyment, and our failure to recognize the interconnection to those non-human systems has made us more in peril and has made the planet more in peril, and that's ultimately what we're facing now with climate change. We've essentially, the metaphor being, if a horse were your only means of transportation, you wouldn't abuse and neglect that one horse. You wouldn't be able to go anywhere. And essentially humans have taken advantage of, used and neglected the planet that they rely on to sustain themselves, and now they're in a very dangerous place in trying to restore and maintain the resilience of that planet. So, starting in the 1970s, there was a big revolution about protecting the environment in the US and outside the US, and that was heralded as a big achievement, and it was in many ways. Prior to that, we didn't have federal environmental law in the US. But it's important to recognize that the federal environmental laws in the US and throughout the world, really, at that time, were very much about responding to pollution, human pollution of natural resources, air, water, land. And the model of how we regulated was a fundamentally unsustainable one, and that is resources were still treated as for our consumption and use. And ultimately, that allowed us to continue in this unsustainable way of our relationship with the natural environment and the planet. Even though we had laws that regulated how we were polluting the environment, the model was still polluting is okay, we just need to do less of it. And so it was very much of a development-focused approach to regulating the environment, and that has proven to be fundamentally unsustainable. So it was better than doing nothing, but it wasn't nearly effective enough in protecting us from the environmental challenges we're facing now with climate change. So there were a couple of laws in the US that didn't take that approach, and that model is something that I'm advocating should be more fully embraced now. And those two laws are the Endangered Species Act, and this is one that picks up on Dr. Aziza's presentation from yesterday, that many humans think about the environment as instrumental in value only. It's only valuable to the extent we can use it and harness it for our purposes. But the Endangered Species Act takes the approach that wildlife species of animals and plants have intrinsic value, that we are going to protect them because losing them is something that is very bad, not just for those species, but for the ecosystem on which they rely and interrelate. So having environmental laws that respect intrinsic value of natural resources and wildlife is something that is going to be very important if we're serious about sustainability now in the era of climate change. And then the other law that was very effective, one of the most effective in the US, is the National Environmental Policy Act. And that was effective because it built in sustainable development thinking. Even before sustainable development was a recognized concept, it built in this idea of we have to regulate with an understanding of development should proceed only if it is sustainable, only if it is somehow recognizing the needs of future generations for those resources, and that we shouldn't just develop because development is inherently good. So those two laws certainly are built into what I'm recommending needs to be addressed in an effective climate change response. And so the second phase of what the evolution of environmental protection involved was this era of climate justice, actually first called environmental justice. And it was a way of the law getting a little bit more sensitive. So we first focused on protecting the way we were polluting the environment, regulating that to some degree, and then we realized that our effort to protect against environmental pollution was not being administered fairly at all times. So there were some marginalized communities that weren't getting the benefits of these environmental laws. And that was what gave rise to this movement known as environmental justice. It was about protecting vulnerable communities, about making sure environmental laws protect all communities and not just the wealthy and the politically powerful. And so that movement started in the late 1980s and has progressed very much until the present day. And it's actually taken more of a climate change focus now. It's called climate justice, even though the traditional environmental justice movement still exists. The idea now with climate change is that climate change is causing disproportionate impacts to vulnerable communities, whether they be low-lying island nations or indigenous peoples or minority and low-income communities. They're always hit with the climate change impacts first and worst, and they are considered more vulnerable than the rest of the population. So the law became more sensitive in addressing these vulnerable populations after initially just trying to address pollution in the first era. And so now, there's a third era that's evolving that we're in now, and that is the one that should be embraced moving forward, and that is this ecocentric paradigm, this idea that the government needs to have a higher burden in protecting all communities, human and non-human, being a steward for environmental protection, and ultimately allowing all communities to have rights. And there's a strong environmental rights movement going on worldwide. And that isn't just about human rights, as we've heard earlier this morning, human rights to water, food, shelter, and health, and so forth. It is also about rights in the non-human communities. So we're seeing lots of efforts now in the courts and legislatures worldwide that are seeking to confer legal protections, legal rights for wildlife and for natural resources. And that may sound very new and strange, but it is a movement that is growing very quickly around the world. And I'm going to give you some case studies of examples of that. So the book actually traces these three categories of non-human, future generations of humans and the non-human wildlife and natural resources communities. So I wanted to start with the future generations of humans case studies. This perhaps is the most inspiring to me as someone who has worked on environmental issues and climate change issues for going on 3 decades now. The work that is happening now in the courts with youth climate litigation all over the world has been particularly inspiring. And this is part of what I've mentioned about rights-based thinking, that we're seeing teenagers and preteens all over the world bringing lawsuits against their governments, seeking to compel their governments to either regulate climate change more effectively when the government is committed to do something, or in the US example, the US has pledged to do nothing on climate change, so a lawsuit has been brought by youth plaintiffs to compel the government to do what it should be doing, regulate climate change. So these lawsuits are happening all over the world. The top 2 on the slide here have been successful and are very important as models for the rest of the world. In the Netherlands, this wasn't just youth, this was youth and adults bringing this claim against the Netherlands government, seeking to have the Netherlands do more to regulate climate change, more than it had already pledged to do under the Paris Agreement. That suit was successful on all legal grounds. It was alleging that the government needed to do more based on Dutch law, EU human rights law, international environmental law, and that case won at the lower court and on the appeal. And then in Colombia, we saw a similar reality where an effort was sought and succeeded to compel the government of Colombia to reduce deforestation in the Colombian Amazon to 0. And just the year before that lawsuit was brought, the deforestation rate in the Colombian Amazon had risen by 40%. And this lawsuit was successful, which is really remarkable. And again, it's on the basis of rights-based thinking that these youth plaintiffs, as future generations, are inheriting something in our planet that is very much in peril, and they were demanding that the government do a better job in ensuring their future as a sustainable one. And so these lawsuits are happening in other countries as well. They're pending in many countries, and some of them are listed here on the slide, but this is non-exhaustive. Canada, there's one pending in Canada as well that was recently filed. So the idea here is that the Juliana case, which is perhaps the most famous, although it still hasn't gone beyond an initial trial phase, pre-trial phase, the Juliana case is really what I'm advocating for as this ecocentric paradigm. There are two claims in the US case, the Juliana case, and one is the government needs to be a better steward, and that is, the argument is called atmospheric trust. And the youth plaintiffs in that case are arguing that the government has a stewardship duty to protect the atmosphere from harm, to ensure that current and future generations are protected from climate change. The government has a duty to manage atmospheric pollution in a way that protects the public. And then they're also claiming that the youth plaintiffs have a constitutionally protected right to a stable climate. And that's something that's brand new in the US. We have other constitutionally protected rights that have been found by the court to exist. They're not written into our Constitution, but they have been found to exist in our constitutional protections. And so this is their claim, that a new constitutional right to a stable environment should be recognized. And these suits are also being brought against the private sector, not just against government, about trying to hold corporations accountable for their greenhouse gas emissions that are causing climate change. And then in the animal domain, this picture is all over the internet. This photograph was actually taken by this monkey. It was a camera that was set up in the Indonesian rainforest, and a photographer had a camera standing, and these monkeys are known to engage with cameras when they see them. And so the monkey took its selfie, many different ones. You'll see this picture all over the internet, many different versions of it. And this really has nothing to do with climate change at face value, but what was going on in this case is very relevant for this book proposal, and that is, this is part of a movement to get legal personhood for animals, and this is part of what could make climate change protection more effective. So the idea here was that the monkey took these photos, and an animal rights group named PETA, People for the Ethical Treatment of Animals, brought a lawsuit saying that the monkey should have the intellectual property rights to that photo, to those photos that it took of itself. And the argument was that the protection in that statute allows people, a person, to have intellectual property rights to the photos. And the court ultimately concluded that person could not mean monkey. It was reserved for non-humans. And so there are other efforts in the courts that are now looking for legal personhood protection for animals in other ways. So they're being brought under our criminal laws in the US, a doctrine known as habeas corpus. And these lawsuits are being filed to get the chimpanzees and elephants released from confinement. And the argument is that they should have some limited rights not to be confined, not to be tortured. And this is where the legal personhood argument comes in. You don't have to talk to be granted legal personhood. Legal personhood is about who matters under the law. So we're seeing more progress in the natural resources domain on this, although some cases have succeeded. A case in Colombia did succeed in recognizing legal personhood for a bear in that case. So where we're seeing the most progress is with natural resources. Rivers have been granted legal personhood. This photo is a river in New Zealand that has legal personhood, which means there are now guardians appointed to protect the river's interests, even though the river can't talk either. Ultimately, this is a step that many other countries are now starting to take. So in the courts in India and Colombia, efforts were successful to protect rivers in those two countries. In the US, efforts have been made, but they haven't been successful. So an effort was made to have personhood for the Colorado River, and that was rejected in the US. But ultimately, these are happening at a local level There have been many successful efforts in the US at a local level to recognize rights of nature, is the name of this movement. So rights of nature is happening in the US and all over the world, where certain aspects of natural resources are getting legal personhood protection, so they are treated like humans. Of course, they need humans to be guardians to represent their interests, but the non-human entities have interests under the law, protections under the law, just like the unborn would as future generations of humans. They can't speak for themselves either, but someone can ultimately represent their interests in the legal system. And it's important to remember, we have lots of existing legal frameworks for that protection. So for instance, under family law, we have children in a divorce proceeding, for instance, in the US. Those children who are in the process of trying to determine which parent they're going to live with after the divorce, the court appoints a guardian to represent that child's interest as to what's in the best interest of that child in that given proceeding. So it's that concept that will be applied to the unborn human populations, wildlife, and natural resources. The same concept. We would need human guardians to protect these interests, but just because that's difficult doesn't mean it shouldn't happen. So I wanted to bring you to where we are now in trying to make this happen. And this is grounded in the idea of sustainable development. So sustainable development has been around for 3 decades, this concept. And ultimately, it's really just been a way of talking about issues. It hasn't been a way for the law to adequately protect the vulnerable and the voiceless. So we are now in an era where sustainable development is so widely applied around the world that international law is starting to recognize sustainable development as customary international law. It's something that we recognize as binding on us, even though it may not be enacted into our laws. So ultimately, if that's where we are, we need at the country levels to approach sustainable development as a mandate and not just as an aspiration. So I'll give you a good example of how that's starting to happen in courts around the world. It's important to remember that the whole concept of sustainable development does embrace future generations. It's built right into the definition. So sustainable development is about developing in a way that is sensitive to making sure future generations have something left to inherit in our planet. And so climate change may be the catalyst to make us think more seriously about what sustainable development means. We know that we're running out of a sustainable planet with climate change as a threat. So if we take that very seriously, and one court in Australia did earlier this year, the idea is that we have a limited budget of how much pollution we can actually put into the atmosphere. This can be on a country-by-country basis, on a global basis. The science is enabling us to make these determinations. What is sustainable? What's a sustainable amount of carbon emissions into the atmosphere that will allow us to have some future without destroying the planet? And so there was a case in Australia that was heard earlier this year, and it was built on this concept that there was a proposed coal mine, and in Australia it's very much like the US. Any kind of fossil fuel development is almost always approved. It's considered inherently good, it's economically profitable. But now the thinking is starting to shift, and this example in Australia was the first time that a proposed coal mine was rejected because it was considered to exceed the proposed carbon budget that Australia needed to fit into in moving forward in a sustainable way. This was such a significant coal mine project that it was deemed unsustainable to grant the permit for that because it would exceed the country's carbon budget. So if we use that as an example, we could apply that thinking to all kinds of fossil fuel developments proposals. We are not under any obligation to extract every last drop of oil out of the soil and every last piece of coal. Ultimately, globally, we have to transition to something more of a green energy economy, and using sustainability as a leverage point to get us there sooner is really what we need to do in terms of being serious about climate change protection. And so this can be a model to apply worldwide to proposed fossil fuel developments. We might start with the largest of those fossil fuel developments. We're not going to transition overnight from fossil fuel to green energy, but that transition has to happen, and the law has to facilitate that transition to happen sooner than later. Otherwise, we're just going to continue with business as usual and use up all the fossil fuel to our detriment in terms of climate change. So I wanted to also give you a sense of, yes, that sounds very difficult to do. What does sustainable development mean? How is that going to be a legal tool for us? And I can just give you an example from the US that if it's enshrined as a constitutional right, which is what the US case is trying to do in the Giuliani case, that there is a constitutionally protected right to a stable climate. Once it's recognized as a constitutional right, then it's just interpreted by the courts on a case-by-case basis. There is some legal standard, and a new project will be evaluated under that new standard. So in the US, we have a woman's right to choose to seek an abortion is protected under our Constitution. And there's a standard known as undue burden that determines whether that law trying to restrict a woman's right to choose is valid. And undue burden is determined on a case-by-case basis. What we really mean by putting an undue burden on a woman's right to choose, the court ultimately concludes whether an effort to restrict that right has been, it is invalid or not under our Constitution. The same could be applied to sustainable development. Even though that's a very general term right now, over time the law can give it more meaning, and courts can determine what it means to act in an unsustainable way with regard to any kind of proposed development that might threaten the planet. So that's something that can happen on a country-by-country basis, and rights-based protections are very important to ensure that those standards will be able to develop. And ultimately, the biggest challenge for the proposal is how are we going to get these entities that don't speak for themselves protection in the courts, and there are already legal standards in the US that enable humans to step in on behalf of either other humans that don't yet speak for themselves, or an effort is now being made to say that that ought to be extended to natural resources and wildlife as well. So it's difficult but not impossible for the law to protect these voiceless entities, and it's about having the will to want to do it. That's the biggest hurdle. Ultimately, getting the law to act in a way that will protect those communities, I think, is the easier part. It's that initial step of wanting to protect the voiceless with these protections is the step we're at right now, and that we need to get to succeed in as quickly as we can if we're serious about protecting climate change. I look forward to your questions and comments. Thank you very much.
Thank you very much, Andy, for the wonderful presentation. I think we've gotten good insights, first from Lisa on regional development, and the lecture which gave us wider perspectives on development in the US, in Australia, and in many parts of the world. So we can take questions now on these issues relating to climate change and the impact on livelihoods, especially the low-income communities. Yeah, any questions?